The record should reflect that Mr. Brooks is now appearing from the other courtroom. Prior to the court taking the short break, the court was attempting to address the filings from Mr. Brooks that he made pursuant to my request, to write down if he had an objection. I have 5 different what I will refer to as filings, one of which he provided to Deputy Wittig at 12:05, so that was right around the time we broke for lunch. A second one, 1:52 p.m., today's date, October 6th, and then there's another 1:58 p.m., October 6th, 2:03 p.m., October 6th, and then looks like the time is 14:28, so 2:28. The other one was received. Mr. Brooks, I'm going to make a record first as to why you've been removed, and then I will hopefully get to the filings. I need you to not interrupt me at the moment. You are unmuted. But after the court completed the preliminary jury instructions and the reading that is to the jurors, I excused the jurors so that they could take a break, but also because I knew there were a number of what I will loosely refer to as objections that were raised by Mr. Brooks. So I wanted to take an opportunity to address those first before moving on to opening statements. As I attempted to address those with Mr. Brooks, there was, from my observation and opinion, and I'll make a finding that it was pretty much a consistent talking over me by Mr. Brooks. I wasn't able to really go through any of these filings with any specificity. I attempted to go through the first one, which I did. I mean, I did tell him I wasn't going to address that. And then we were talking about his second one when really it kind of devolved from there. The record is very clear that Mr. Brooks has been advised on multiple occasions of my expectation regarding courtesy and decorum in this courtroom. I've referred to it many times that there's a very simple rule of civility I expect him to follow at a minimum, and that is to not interrupt. It shows a complete and utter lack of respect for the court process, the court proceedings. It interrupts the court as the court is attempting to make a record of what is happening and decisions that I am making. And after repeated warnings to him, the court made a determination that he had forfeited his right to be present in the courtroom while we discuss his filings. The record will reflect that Mr. Brooks did not give consent. I am still continuing with my findings, sir, so I'd ask that you not interrupt me. Mr. Brooks, I'm not done. I'm going to mute him because frankly, can be difficult to keep one's train of thought when you are consistently interrupted, which is why I believe he engages in the conduct that he does, because it's plain and simple, it is disruptive. It disrupts my thought process, it disrupts the proceedings. I was so pleased, Mr. Brooks, when you were able to follow the simple rules when the jury was here and I was going through the jury instructions. I know you had some objections, you wrote them all down, you followed that procedure. I told you I would take those up after I got through the jury instructions. I was attempting to do that, but then you started in with your antics, with your interruptions. It doesn't matter to this court if you're mild-mannered, if your tone of voice is a normal tone of voice, meaning it doesn't matter to me that you're not raising your voice, you're not making any threats or anything like that. That certainly would take things to the next level, in my opinion, but but it's not necessary for this court to make a finding that your behavior is disruptive. And this obviously comes on the heels of your conduct this morning, where you spent the vast majority of the morning in the other courtroom based upon your conduct. And I'll once again rely on the decision in Illinois versus Allen, 397 U.S. 337, a U.S. Supreme Court case from 1970 on the options the court has constitutionally when faced with a disruptive defendant, someone like Mr. Brooks, who cannot conduct himself consistently with the decorum and respect that is inherent in the concept of courts and judicial proceedings. The consistent interruptions are not only disruptions, but it interferes with the proper administration of this trial. It disrupts the dignity, order, and decorum of this court. Those are the hallmarks of all court proceedings. I'll make a finding that he flagrantly disregards in the courtroom elementary standards of proper conduct by repeatedly interrupting this court, and therefore he has forfeited his right to be present while we discuss all of these filings. I'll also make a finding that the technology that we are utilizing here today, we are Polycom to Polycom. The audio and video have been working very well this afternoon. No issues with that, and that it's the functional equivalent of Mr. Brooks being in this courtroom. It gives him the opportunity and the ability to meaningfully participate while the court is still able to control his behavior by exercising the mute button, as I have repeatedly throughout these proceedings. I believe all of the documents speak for themselves, I should say, but what I will do is go through them one by one from the beginning. Since they're Mr. Brooks's filings, his position has been made known. I'll ask the state to respond. If I feel any additional follow-up is needed from Mr. Brooks, I'll ask him for that, and then I'll make a decision. So even if that's backtracking a little bit, it's a little bit easier to do that with him in the other courtroom. So the first one that I will deal with is the one that's got today's date and 12:05. I addressed it earlier in terms of that I did not believe it was a filing that required any court response, and I'll ask the state if the state sees any of that differently.
No, Your Honor, and I would cite the court's United States versus Benabe, B-E-N-A-B-E, at 654 Fed 3rd 753. It's a Seventh Circuit case from 2011. Specifically, there's very instructive language on page 767. This case involved a defendant who identified himself as a sovereign citizen. The court goes into a nice discussion as to such claims having no merit whatsoever. The quote is, the proposed sovereign citizen defense has, quote, no conceivable validity in American law. I think that's applicable to several of these filings here, Your Honor, and I think that's relevant authority throughout the remainder of this trial, that these sovereign citizen defenses have been attempted. There's a lot of cases on this. That's the most recent from the Seventh Circuit that I could find. In no way have any of these defenses, such as his name, the jurisdiction of the court, the fact that the state's an entity, any of these efforts that Mr. Brooks has tried to put forth have been soundly rejected by the courts, and there's significant case law on point, but that's the most recent and appears to fit really well with the facts of this case.
I would note the documents he refers to in this particular piece of paper references the notice of special appearance, the statement of particulars, both are by affidavit. Those are two of the common sovereign tactics, and I believe Benaby and the language that you cited is directly on point, and that is why I can simply deny the request to address those filings without any further discussion or hearing on them, even without giving Mr. Brooks an opportunity to further respond. The second statement, and I note he's raising the objection, and I'll indicate for the record he's objecting to what's being ruled upon. Then the second filing, we heard him discuss at length, so I'll just have the state respond to that, and that was his claim that his First Amendment rights to freedom of speech are not being honored in this courtroom.
So the court has been abundantly patient in allowing Mr. Brooks to make appropriate, relevant legal arguments. The court is 100% accurate that no constitutional rights is absolute, and they can be fettered under appropriate situations, and you've made an excellent record as to why that is appropriate in this case.
Mr. Brooks is raising his objection sign. Since he was given an opportunity to address this previously, I'm not going to give him further opportunity and simply indicate that he will be allowed at appropriate times under the rules of evidence, under the to present his defense. It appears to me at times he may confuse the ability to file something into the record with the ability to present evidence. We have yet to start the evidentiary phase of this trial. In addition, any of his specific objections should be brought by motion. Even if that's an oral motion, it should be based in law and fact and request specific relief. His filings make claims that have no underpinning in law or fact. It's really conclusory. This court is under no obligation to address, conclusory statements by him that are not properly made, both in form and in substance. This record's replete with references and instances of Mr. Brooks just simply spouting various amendments or theories without those fully being established in the record. And again, no constitutional right is absolute. The First Amendment rights of an individual can certainly be fettered. That is especially true in a court of law where there are rules of evidence, rules of procedure, where we have the standards of courtesy and decorum. He can present his defense. He has a right to present a defense, but his rights to do that must comport with the law, and that law is what I've already pointed out. So I'm not sure really how to address, are you making a judicial determination? Everything that I do when I rule on something is a decision that is made by this court. So I've answered this. We'll move on to the next one. And he is raising his objection, and that's fine. He can do that. His objection will be noted for the record. He also raises in the next filing at 158, I still motion to prove jurisdiction, please. Also motion to dismiss for no proof of jurisdiction. Also motion for finding of fact. Again, none of these things cite to any legal authority or any factual basis, nor do they request any specific relief. Here's what I will rely upon the Benaby decision from the Seventh Circuit, that these are just various arguments raised by sovereigns that have been debunked and have been addressed that have no place in our justice system. And therefore, I will deny the requests in that piece of paper summarily without further consideration. I know he makes repeated objection to either how I say his name or how it's referenced in the caption. There's a continuing objection that I will note. His filings speak for themselves, how he wishes to be addressed. This court will refer to the name that is on the information in this case. That is the official charging document, and that is what I will do. If I mispronounce his first name at times, my apologies. I know I said his name repeatedly throughout those jury instructions. I know when I first had hearings on this case, even his own attorneys referred to him as Darrell. And it was only after I viewed his recorded interview that I learned it was Darrell. I asked him at one hearing, how do I say your name? Is it Darrell? And he said, that's right, or words to that effect. I may not have the exact quote, and I'm not quoting him, but he confirmed for me on the record, at least at that point, what his first name was. So his continuing objection about his name is so noted. It's preserved in the record based upon his filings, and I'm not going to address it further. Frankly, his last document, which says a plea is to argue facts, I don't intend to do that, and I never agreed to or consented to a, quote, not guilty, quote, plea. My attorneys never got my consent for a not guilty plea. I don't understand. The law is very clear that a plea of not guilty, even when a defendant stands mute, is what the court proceeds with. It is true in this particular case that plea was entered on his behalf, but the fact also remains that in order for that plea to be changed to something else, meaning a guilty plea or a no contest plea, the defendant would need to go through the plea questionnaire waiver of rights form and have to knowingly, freely, voluntarily, and intelligently waive all of the rights that go along with that. In other words, this court is simply constrained by the law to proceed as if not guilty pleas were entered on his behalf. So I've addressed that. I don't need any further argument from the parties. I will note Mr. Brooks continues to have the objection sign raised. The other thing I want to make a record of, we did have the civilian jury bailiffs check with the juror that was identified by Mr. Brooks, and that juror confirmed she has not attended any proceedings. So that issue is addressed now. He's holding up his objection sign. Mr. Brooks, I frankly did that for your benefit. You raised what really is an important issue, and I appreciate that. I was a little surprised by it, but then when I heard you explain further, I thought, he's got a point there. He had been removed for some of those proceedings. You may not have seen her. I'm not making a finding on that, and so that's why I backtracked a little bit, said I would look into it. So I'm not sure why you're objecting at this point. I took an important piece of information that you were relaying, and we had it, in this case, it was confirmed that the juror did not attend any proceedings, and so that will address your issue with her. All right, now the next step would be opening statements. So, Mr. Brooks, you have demonstrated in the past, and I'm going to unmute you, that when the jury is present, you are able to maintain civility, show them respect, show the courts and the process respect and dignity. I certainly am willing to have you brought back over while the state gives their opening statement, and certainly if you choose to make an opening statement, for you to do that in this courtroom in the presence of the jury. I know you're holding up your objection sign, sir, but I am giving you the opportunity to come back over here. Would you like to come back to this courtroom? Record to reflect, he's holding up his objection sign. It appears that he's writing, I don't know what, of course. Mr. Brooks, I'm going to ask you again, would you like to come back to this courtroom for opening statements?
So I'm on the record.
You are. If you would please address my question.
So you want me to come back over there just to get brought back over here?
That's not what I asked you, sir. I told you, I advised you I would like you back here. It's always my preference that you're here. You demonstrated previously that you can follow some rules when the jury is present. The jury's going to be brought back in shortly for opening statements. The state will go first as they bear the burden of proof, and then you will be given an opportunity to also present an opening statement. So my question to you is, do you want to come back to this courtroom, sir?
So I can get sent back over here, because as soon as I say something, I'm going to get sent out.
Mr. Brooks, it's your conduct in this courtroom. It is what dictates the court's response. If you follow the rules of decorum and courtesy and civility, you will remain. But if you choose to not do that, then you run the risk of once again forfeiting your right to be present.
You say that even though I never consented to being taken out. You say that everything is about the decorum and all this. That's what you say. But when I'm raising issues of understanding, which I keep telling you I don't understand, then it's looked at as being disruptive. It's looked at as intentionally trying to be disruptive. And I don't understand why everything I say has to have some type of disruption title to it. It's even been put on record numerous times with inaccuracy. Even what happened today. Nobody reported on record about me being bruised up and having to get bandaged up and all these things, but it was put on me, laid at my feet, as if me, quote unquote, being disruptive was deserving of what happened to me. I'm simply trying to have a fair trial. And if I don't, forgive me for being this way, Your Honor, but if I don't understand, I'm going to ask questions. That's the only way I can have clarity, is by asking questions. And you have refused to answer anything, but I have to answer everything you ask me. Where's the give and take? It should be fair. I'm not asking for legal advice. I'm not asking for nothing like that. I'm asking to simply have clarification so that I can understand. I cannot put on an adequate defense if I don't understand something. Do you see these boxes I got right here? Do you think I was able to go through everything in those boxes?
Mr. Brooks, I'm not going to go through this with you again where you attempt to put on the record all of these issues that you have when we're in the middle of a trial. All right? You willingly waived your right to an attorney. I made all of those findings, so we will go forward.
You made those findings.
I am not obligated to answer questions.
You made
when
those
you
filings.
ask me questions, I'm going to mute him.
Yeah.
I am not obligated to answer questions that explain procedure or the law. I am obligated to address motions that are based in law and fact. I'm obligated to address objections, for example, whether it be to testimony or evidence or questions posed to witnesses. But I am not obligated, sir, to provide you with an explanation of the law, of the procedure. And with that, since I gave him 2 opportunities to answer a very direct question, and that was, do you want to come back to this courtroom? And he chose not to answer it, but instead ask a question and then start making statements about his lack of understanding. I will find that his non-response, that he has not answered directly, which to me says he's not willing to follow the rules of decorum and courtesy and civility, and without such a pledge, he will remain in that courtroom. He's muted. The record should reflect. It appears he's talking as well. He's making hand gestures. His lips are moving behind the mask. And I just wanted to make a record of that. All right, then we will have the jurors brought in, and then the state can then proceed with its opening statement. obstruction, and so that's why you gotta look that way normally, but.
Oh, okay.
Mr. Wichel's doing the opening.
Okay, thank you. Thank you, Teresa.
Sure.
Be seated, everyone.
All right, at this time, we will give the parties the opportunity to make opening statements. Does the state have an opening statement?
Yes, thank you.
And just for the record, Mr. Brooks is appearing from the other courtroom. That should not influence your verdict in any way, ladies and gentlemen of the jury. Go ahead, Attorney Wichow.
Madam Clerk, can I have the screen projector?
Middle.
Yes.
I just, when we do that, make sure we confirm it should transmit, but we'll make sure it's transmitting over there as well. And if that's okay, if it happens, we may lose video of Mr. Brooks for the time being, as the state is using what appears to be a PowerPoint. Just confirm with me, Deputy Wittig, that when it starts that it is able to be viewed and heard over there. Go ahead.
It was a cold.
They can't see it? All right, hold on. I may have to utilize the Zoom for that then, so it's... All right, let me do this. No one needs to leave. We're going to go off the record, though, so that I can set up another way to do this so that there's a share screen capability. Okay.